few minutes for questions. There's a question here, actually, which perhaps if I ask Jahad first, that you were talking about the issue of tactics available to claimants and respondents, and there's a question about the extent to which the threat of a cost application or cost applications themselves might be a factor, particularly for respondents. I think we've probably all experienced a situation where you have a discrimination claim where your client is on the receiving end and it's a very weak claim, but when you come to ask for costs you don't get very far, and I wonder whether that was your experience and whether you see cost warnings as a tactic which respondents are going to get very far with in this day and age.
I think so. In terms of getting far, I'm not sure. We all know that the level of cost awards has now been increased from 10,000 to 20,000.
Absolutely, yeah, that's right.
So my view is that I think increasingly claimants will start asking for costs as well, arguing that the defence is misconceived, and therefore by continuing to pursue the claim it constitutes unreasonable conduct, or continuing to defend the claim constitutes unreasonable conduct. But from a tactical point of view, I would, most certainly always threaten, if you've got a frivolous claim, then early on just inform the claimant that this claim has we don't believe that this claim has reasonable prospects of success, we believe it's misconceived, and by pressing on, that constitutes unreasonable conduct. And I think judges will increasingly start making, if you look at the Employment Tribunal statistics, it shows a gradual increase in the number of costs awards that have been made. So, time will tell given the reforms. But I think, respondents should, actually push for costs. And I've not personally had any cost awards made against any clients that I've acted for in the past. But I think it's getting, if you look at the tribunal rules, they were reformed in 2004. I think we're sort of moving into the CPR, the Civil Procedure Rules. They're becoming a lot more formal.
Yeah, that's the idea, I think.
So I think that's the idea. I think that's where we're heading in the direction of. And we've increased issue fees. There's going to be not increased, but that's been introduced in terms of pursuing claims. And as I mentioned, one of the tips is to actually ask for a deposit order and or the claim to be struck out. And you'll probably agree, and it's probably something that you both do in practice as well. If you've got a frivolous claim, then it may be worth asking the tribunal for a pre-hearing review, for example.